the inside story on the issues that affect you and your community. This is Local 12 Newsmakers.
Good morning and welcome to Local 12 Newsmakers. I'm Dan Hurley. Early this summer, Ohio Senator Bill Seitz introduced Senate Bill 349, which he says is designed to protect those who own rental property from what he considers unwarranted and expensive legal claims filed by fair housing organizations and bring Ohio statutes in line with the federal law. Senator Seitz argues that in cases in which fair housing agencies use testers to determine if landlords are discriminating on the basis of race, color, national origin, religion, gender, family status, or disability, in fact, there is no actual injured party. But the property owner is forced to defend themselves before the Civil Rights Commission or in court, which can be an expensive proposition. Senate Bill 349 proposes to make actual damages attorney fees and punitive damages discretionary. Any damages that are awarded could not be paid to a fair housing agency. Punitive damages would be awarded only in cases of actual malice and be limited twice the amount of actual damages and not exceed $5,000. 349 would allow respondents to recover attorney fees if they prevail and exempt housing providers who own fewer than 4 units. I contacted Senator Seitz's office over a month ago to arrange a Newsmakers interview about 349. We booked this date to accommodate the senator's calendar. Yesterday afternoon, the senator's office contacted me to say that a conflict had arisen and the senator could not be here. At that point, I had no choice but to go forward with this topic with the other guest who was scheduled to join us. I am joined this morning by Elizabeth Brown, the Executive Director of Housing Opportunities Made Equal. Since 1968, HOME has worked to ensure fair housing in Greater Cincinnati, including using testers. Elizabeth, I think it's welcome back to Newsmakers.
Thank you.
Been here before. Let's begin with what HOME does, and you're just one example of a fair housing agency that would be present in, I would suspect, most large cities at least in Ohio and the United States.
Right. Many of the large cities in Ohio have private fair housing agencies like HOME. We're a nonprofit. We're not the government agency, although we get grants from the government. It's a very small nonprofit. We've been around since 1968. Actually, we were a volunteer organization before then of folks who were did not feel that segregation in our neighborhoods was right. They called it open communities at the time. And then when fair housing laws were passed in 68, they incorporated the agency, and our mission is to eliminate what is now illegal housing discrimination. And that's what we've been doing since 1968 and are still doing today.
Well, let's talk about the methodology of using testers. What does that mean? How does that actually happen?
Right. Housing discrimination is hard to prove. If somebody comes to us and says that a landlord said, no, I'm not going to rent to you, I don't rent to blacks, it's their word against his. If they bring a complaint, he'll say, oh, I never said that. The courts have found what we call testing as very good evidence. What HOME does is send out 2 people who are objective actors, basically, and they go apply for an apartment. And very often, if discrimination is happening, the person who's protected, whether it's a family with children or someone who's African American, will be treated very politely by the landlord. Matter of fact, very friendly. But will be told, gee, I'm sorry, I don't have anything. You seem like a really nice person. Why don't you come back in a couple months if you're still looking? And then a few hours later, a white tester or a tester without children would be showing 2 or 3 vacancies. So that evidence, when brought up in court, is considered very good evidence of discrimination. It sort of proves that that's what's happening, more so than just getting into a he said, she said.
Because this becomes a legal issue, right, and evidence that stands up in court or in front of the Ohio Civil Rights Commission is absolutely essential. This is not just you can make a complaint.
Right, exactly. You have to be able to prove the complaint. There has to be some evidence. And very early on in the fair housing laws, this method of testing was considered by the courts excellent evidence.
So I think we all know that at the beginning of this, and even before you were organized, or 1968, that volunteer period ahead of time, race was the primary issue. Mm-hmm. I rattled off a whole bunch of things. Where are we today in terms of where people encounter problems? To what extent is race still an issue? To what extent have other things become an issue? Were there times when certain categories were really problems but have ceased to be or have become minimal? What's the flow of this?
Right. There has been somewhat of a flow. In the beginning, it was primarily race. We still do receive a lot of racial complaints. They're much harder to prove. Landlords no longer slam the door. It's rare, the case we had recently with a white-only sign. I mean, you don't see that too much. That becomes easy to prove. The subtle discrimination that we find in race is much harder. But in 1988, the law was amended because our society